very warm good evening to all of you. Welcome to the 114th IDG session. Today, we all are honored to have with us Justice Shri A.K. Patnaik ji, former judge of the Supreme Court. Today's session will be entirely question and answer based on legal, constitutional, and judicial matters. Thank you so much, sir, for agreeing to have a session with us today. The moderator for today's session is Toshita Jha, one of the co-conveners of IDG. I would also request all the attendees to keep their videos on, microphones on mute, and post their questions through chat box only. I would request Toshita to take over.
Good evening, sir. Once again, I would like to thank you for agreeing to have a session with us. Although you don't need a formal introduction, but just for the sake of formality, I would like to ask Ujjwala, one of our members, to give a formal introduction.
A very good evening to all. I, Ujjwala Singh, member of the IDG, would take the privilege of welcoming you to the 114th Informal Discussion Group session. With us today, we have Justice A.K. Patnaik, former judge of the Supreme Court of India. Having completed his higher education from Delhi University, Sir joined the bar in Orissa High Court in 1974, specializing in commercial and constitutional law. Elevated as a judge of the Orissa High Court in 1994, Sir also worked as a judge in the Guwahati High Court before being appointed as the Chief Justice of the Chhattisgarh High Court, followed by the Madhya Pradesh High Court. In 2009, Sir was appointed as judge of the Supreme Court of India, where he was a part of several landmark judgments, such as the 2G Spectrum case, Akshardham Temple attack matter, striking down of protection of MPs during pending appeals cases, commuting the death sentences of Aftab Ansari and Jamuruddin Nasir in the American Center attack case, to name a few. Sir is a renowned public figure and has served as the chairman of the Supreme Court Legal Services Committee as well. We are honored to have him with us today. In this session, he will be answering questions on legal, constitutional, and judicial matters. Thank you.
Sir, do you want me to read out the questions?
Yes. You read out the question and answer. Okay. And person who has put the question, he can put seek a clarification if he is not satisfied that the question has been properly answered, right? So I would like to meet his query also. Right?
Okay, sir.
Am I audible to you?
Yes, sir. Yes, sir, you are.
All right. Yes.
So, yes, sir. First question has been sent to us by Priyansh, and he wants to ask that as you were part of the bench increasing the power of CBI in 2014, what are your views on various state governments, for example, Maharashtra, West Bengal, revoking the general consent that CBI has to investigate? Does it hinder the whole process of investigating agencies?
All right, now let me tell you that Supreme Court judgment of 2014 that we are speaking, that was not with regard to offences committed in the state territories, right? It was with regard to offences committed of certain class of officers, right? And the Supreme Court said you can't discriminate. Only some classes you will require the sanction of the government. Some classes don't require. So that discrimination is not possible. That has nothing to do with the consent of the state governments. Now, as you know, our constitution is the federal system, right? And under our constitution, Article 246, if you read, 245, the constitution, legislative powers have been distributed between the central and the states, right? So there is a central union list, there is a state list, and there is a concurrent list. Right? Now, in the state list, in entry 64, mentioned is offences against laws with respect to any of the matters in the state list. Right? So, investigation of offences or matters in the state list, right? Any law that is made in the state list, if some offences have been committed, then in that case, the consent of the state government becomes mandatory, even if it's done by the CBI. Now, CBI has been set up under Special Police Establishment Act, Delhi Police Establishment, And Section 6 of that Act recognizes this constitutional provision and says if the offences are inside the state, right, and for which the state has the power, then you can't do it without the consent of the state. That is only the recognition of constitutional provision. Constitutionally, it is not permissible. So, therefore, the state government is required to give the consent, and they will give the consent for the CBI to do so long as they have total trust in the CBI in investigating it. What has happened now in our country is, in the center there is a what we call NDA government. In Maharashtra there is no NDA government. There is a government which is different, that is of Shiv Sena and Congress. In West Bengal, the Trinamool Congress. Right. In Chhattisgarh, there is a Congress government. So they think that the general consent, we should not do it. Earlier, the general consent, they had granted because the party was the same, or the government party was the same, and they had. When they found that CBI can be used, I'm not saying is being used, can be used for political reasons inside the state, then they say, why give this general consent, withdraw it? Right, in a particular case, we can see. So this, it is within their constitutional power, they are doing it, and they are doing it because they think that they should not give this power to the CBI. In an individual case, they will see. And that West Bengal matter came up to Supreme Court, where a lot of people were killed, out of which the ultimate Mamta Banerjee came to power. Land acquisition matters with regard to for the Tata vehicles and all that. Manufacture there in Nano or something. Tatas wanted to manufacture earlier there. And then there was a lot of land acquisition done. And land acquisition was resisted. Right. And the matter was challenged. Whether CBI can be entrusted with this power to investigate. Right. So the whole matter came up to Supreme. It was once before our bench. And we referred it to a larger constitutional bench. The question was whether CBI can be entrusted to investigate into such offences inside the state. Right. So the Supreme Court, a constitutional bench of the Supreme Court held that only the High Court can direct or the Supreme Court can direct. Right. That is an exercise of judicial powers under Article 226 and Article 30, where rights are violated. Right. In very rare cases, this direction will be. But normally, any offences taking place within the state and against the state law, the consent of the state, and they are within their jurisdiction to do it. Tomorrow, if the CBI as an institution ceases to be a politically dominated institution, they feel so, states feel so, they will say, all right, we'll give us their consent. But today, as the position stands, the political atmosphere is such, right, so divisive, right, that the states feel they are not confident. Why give them consent? They will go and book something against us, right, unnecessarily, and get into political problems. This is the position, right? Yes. Any question out of this? Whoever has put this question, any answer he wants? All right. Now we can move on to the next question.
So, next question, Priyansh would like to ask himself. He was really excited about this question. So, yeah, Priyansh, ask your question.
Good evening, sir. Sir, so my next question was that we've seen that the Supreme Court and various judges in the Supreme Court have been calling upon young lawyers to join the judicial services. But on the other hand, the Bar Council of India has been constantly pushing for mandatory practice for 3 years before giving the entrance exam. So what, according to you, could be the right balance when we try to attract the young minds to the judicial services and at the same time maintaining the standard of the judiciary, like the competent person enter the service?
See, what happened was earlier, the provision before the 90s, even before around 94, 93, 94, the provision was unless one puts in 3 years of practice, you can't enter into judicial service. Judicial service here means the subordinate judicial service, not of the rank of district judges. Mind you, district judges require 7 years experience of lawyers. Now, what happened was, when they wanted to improve the quality of judicial service, of judicial officers, there was a commission appointed on Jagannath Sethi, who was a Karnataka judge, and he came to Supreme Court also, right? Sethi Commission. Now, Sethi Commission went into this in depth and found out that we can't attract the best of talents unless we do away with 3 years practice. Why? Because the youngsters who are coming out from universities, from even good law universities, they would like to job immediately. They are not prepared to wait for 3 years. And they are being attracted to all India services, other all India services, like the IAS, like the Indian Police Service, like the allied services, income taxes, and they join there. Right. So when they join there, judiciary loses the service of these young talents who are bright and competing in the all India field and coming up. Right. So therefore, the recommendation of the city was that do away with 3 years service, 3 years practice. Right. And just as in other cases, as soon as you graduate, you can take the IAS exams or the IPS exams or the allied service exams. Let they also take the judicial service exams. In that case, they have the option. And what happened thereafter, after Sethi Commission years, the salary of the judicial service, the initial recruit of a judicial service man, went more than the IAS initially. It was recommended. You know that or not? Right? Better perks, better facilities. That was done pursuant to a direction of the Supreme Court. Right? When in the Supreme Court, the central government registered it, and they are dominated by IAS officers, the bureaucracy is dominated by IAS officers. They registered it and said, why all India services exam people are giving, and the IAS people, they are getting this much salary. How can the judicial service initially could get higher salary and better perks? It is not possible. Must be given. So it was very nicely countered by the judge of the Supreme Court by saying the executive power under the Constitution is not exercised by secretaries of the IAS officers at any level. It is exercised by the ministers. Right? Council of Ministers under the Constitution. Not by any IAS officers or IPS officers. Right? Whereas the sovereign judicial power, we have to understand, sovereign judicial power, even by the lowest magistrate in the hierarchy of judiciary, is exercised by him only, nobody else. He cannot consult the Chief Justice of India or he cannot consult the Chief Justice of the High Court to exercise his powers. He will exercise his own judicial mind. So that means a big responsibility. Whether a person will be given a bail or not, big responsibility. Whether a person will be convicted or not, for any means small offence, is a big responsibility. It's a much more onerous task, most onerous responsibility. Therefore, the IAS officer initially cannot match the functions of the judicial officer when he is exercising sovereign powers and so on responsibilities. The salary will be. So they wanted to ensure that the best of people with integrity and talent should come as initially judiciary. Therefore, they got rid of the 3 years. Right? And the Supreme Court itself said, I forget the name, they said, no, 3 years, get it off. Right? Now, what has happened is, when I was posted Chief Justice of Chhattisgarh and also Chief Justice of Madhya Pradesh, many of the members of the bar, lawyers, met me and said, sir, these judicial officers, right, who are initially, they have no experience. No experience of practice of law. No grounding. They have come straight from the universities and taken the exams. So how can they decide a matter judicially? They had a point. They have never applied. They have not seen what a plaint is. They have not seen what a written statement is. They have never handled a trial, right? As a lawyer, they don't know how witnesses are examined. They don't know what really is the procedure for in civil matters and criminal matters, and we have entrusted them with the power. Now, for this also the Supreme Court found out an answer. And there's also laid down. See, when we are taking this fresh recruits, they must go through an initial foundation course. Right? And the foundation course is done with the State Academy. And I was there in the State Academy head, Judicial Service, Judicial Secretary Orissa. Then all the heads of the Judicial Academies, all the judges, were called to National Judicial Academy of Bhopal. And there we laid down the syllabus, the foundation course for this initial recruits who did not have any school. Right? So initial recruits who did not have experience were to be given a foundation course so that they can handle it, and their 3 years experience, but very difficult. What experience can teach you, your foundation course cannot teach you. But in any case, the position remains the same. Initially, that Supreme Court tried to undo it, but I think there was some inner resistance. It was posed to me also by Justice Balakrishnan. So we should not do it. That is the judgment of the Supreme Court. That has to be reviewed. That I don't think that has been reviewed as yet. As a result, the 3 years course remains. And constitutionally, you have to look at the provisions. 234, Article 234 is for initial recruits in the judicial service. Right? Those rules are made by the state government in consultation with the High Court and the Public Service Commission. Right? Bar Council has nothing to do. Lawyers have nothing to do. Right? So that is how it has been amended. It was amended, 3 years course, 3 years was got rid of. Right? And initial recruits were straight away taken from the universities. I remember when I was Chief Justice in Madhya Pradesh, some national university students applied for judicial service. Right? But the results had not come out. Right? And they applied, they filed a writ petition, what to do. I said, no, you please take the exams. But at the time of the initial recruitment, when the recruitment is actually made, right, when the notification comes out, after all this selection, because you have to go through, number one, you have to go through a written examination, then you have got to go through the personality test before the Public Service Commission. After, when you are selected, your results should have been out, and you should have passed. Otherwise, no. With that direction, I disposed of the commission in Madhya Pradesh. So therefore, for initial recruitment not required. But for district judges, right, 7 years experience is required because they have to conduct a session trial, they have to conduct murder trials, right, rape trials, very serious offences. For that, a minimum of 7 years is required. I don't think the Bar Council is right. Bar Council, they agree by the fact that they don't, unless the lawyers are there, some experience. They don't pass right on, but I think it will gradually, they pick up. They pick up very well and they go up. Yes. Yes, next question.
Yes, sir. So Rudranil has sent a follow-up on what you've said. Rudranil, you can unmute and speak your question.
Yeah. Good evening, sir. My question is, sir, as aspiring lawyers, many of us are interested in pursuing judicial services. Could you please tell us a bit about your initial experience as a judge? And also, sir, how and how much do you feel your time at the bar helped you in the bench?
No, initial judicial service does not require any experience. 3 years experience. Right, doesn't require. Rather, if you get delayed, you lose in seniority. So you must join. As soon as you complete it, you must take the first chance if you want to get into initial judicial service. Otherwise, you lose out in seniority. Right. Though, under the new rules, very interestingly, if you perform very well, right, for the next recruitment, you may get an accelerated promotion on the basis of your performance. And your juniors may be left behind. You may have gone marked because that is also part of the reforms that judicial service work carried out. Right? So you may get an accelerated promotion. But why should you lose out right from day one? Only what you've got to do is you have to work hard, very hard, in the initial years of service. You may not have experience as a lawyer. You work out. But for district as recruitment, you cannot get in any case, unless you have 7 years experience. Yes. You left out the second question.
Yes, sir. I'm just reading it. Yes, sir. So the other question is, how to demarcate between judicial activism and judicial overreach in today's time. This is also in furtherance of what Soham has asked, that about state consent in judicial activism. So this is the second question.
All right, judicial activism. Judicial activism is when you are not having a strictly legalistic view of the provisions, right, of the constitution or the law. You are playing a proactive role as a judge. You are concerned with societal problems, socio-economic problems in society. And you are very active as a judge. You are not going there only to perform a function and get away, right? And get a salary. You are concerned and committed for justice, right? So you look for some gap in the law, some provision in the law, the constitution to give some relief, to do some justice. That is called judicial activism, right? I'll give you a simple case. Have you heard of the Lee Thomas case that you were reputation of victim act disqualification you mentioned, Ujjwala mentioned about my judgment? In that case, the challenge was to Section 8(4) of the Reputation of Victim Act, which provided that if pursuant to a conviction of an offence, you get disqualified, a member of parliament gets disqualified, or member of state assembly gets disqualified, and he files an appeal against the conviction, right? Till the appeal is decided, he will continue in the House. If in parliament he will continue, if in assembly he will continue, till the appeal is decided. Right? That means he is convicted for an offence for which there is a disqualification, like Prevention of Corruption Act. More heinous crimes, there is a disqualification, and he is disqualified, but his disqualification will remain in abeyance if he files an appeal and the appeal is not decided, till the appeal is decided. As a result, members of parliament, the moment they were disqualified, they were convicted, they were filing an appeal. Right? In the appellate court will decide it, Certainly after 5 years, not within so easily time. They were merely happy, absolutely happy. Right? They were never disturbed. So as a result, the disqualification provisions were of no effect for those who were sitting members of parliament or the legislature. But for those who are going to contest, it was an effective provision because if you have been convicted, you can't contest. That is the law. You are disqualified. Right? So, when the matter came before us, we said, no. If you can't contest an election to get into the house, how can you continue in the house the moment you are disqualified? This is the judgment against the purpose. Right? And this is part of the constitutional provision that the disqualification is the same for those who want to get elected to the house and for those who want to continue in the house. Say, you can't have two sets of rules. This is the effect my judgment in Lee Thomas case. Right? This is judicial activism. Because the Supreme Court has the power to strike down a law made by Parliament as ultraviolate the Constitution, and that is what the Supreme Court did. Right? Supreme Court said this provision in section 8(4) of the Republic Act is ultraviolate the Constitution. Struck it down. That we have the powers. It is part of the powers of the judiciary to strike down as ultraviolate the Constitution. Right? But separate the what you call judicial overreach would be when a judge or judiciary steps out of the limits, constitutional limits of its powers and goes into the legislative domain or the executive domain. Policy making, lays down policy, or lay down the law. Right? You see, as a follow-up, I will give you the follow-up of Lily Thomas judgment. This matter went to a 5-judge bench. My judgment and certain other issues. Right? And they gave some directions. 5-judge bench, right? They gave a direction, constitution bench later on. They upheld my views, they confirmed my views, that's correct. But there is a case of striking down. But we cannot, they say, we cannot start legislating for Parliament. That's for Parliament. Right? And if I may quote from that judgment to show what is judicial overreach, I'll quote from the judgment, and then you'll understand what is that judicial reach. This is what he says. They issued some directions, 5 judgments. We have issued the aforesaid directions with immense anguish. For the Election Commission cannot deny a candidate to contest on a symbol for party. Then he says, a time has come that Parliament must make law. This is with electoral reforms. Right? Make law to ensure that persons facing serious cases do not enter into the political stream. Right? It is one thing to take over under the presumption of innocence of the accused, but it is equally imperative that persons who enter, in this case, you see what has happened is, the PI was that those who have cases against them, criminal cases pending, but they have not ended up in conviction, they also should be debarred from election. But the Supreme Court said by innocence, they are innocent until they are convicted. And in any case, it's for Parliament to look into it. Right? If Parliament can make that law, it's all right, but we can't make that law. Right? Parliament can make a law till your innocence is established. Right? You can't contest. That will be challenged to Supreme Court, but that's a case. Then for Parliament to make representative plan, they could provide for it. So he says, a time has come that Parliament must make a law to ensure that persons facing serious criminal cases don't enter the political stream. It is one thing to take over under the presumption of innocence of the accused, but it is equally important that persons who enter public life and participate in lawmaking should be above any kind of serious criminal allegation. Supreme Court says so, but Supreme Court saying we are helpless. Right? It is true that false cases are fostered prospective candidates, but same can be addressed by Parliament through appropriate legislation. Right? The nation eagerly waits for such legislation, for society has a legitimate expectation to be governed by proper constitutional governance. The voters cry for a systematic sustenance of constitutionalism. The country feels agonized when money and muscle power become the superpower. Substantial efforts have to be undertaken, right, to cleanse the pollution of politics by prohibiting people with criminal antecedents so that they do not even conceive of the idea of entering into politics. They should be kept at bay. Right? But they say we can't help it. Why? Lawmaking wing of this democracy, we are sure, of this country, will take upon itself to cure this maladies. Left it to the legislature. If they had gone ahead and said they can't do it, they can't contest elections, it would have been a case of judicial overreach. See that? This is the subtle distinction. Yes.
Okay, sir. The next question has been sent to us by Samarth, and he asks that how do you see and justify the opaque and complete information asymmetry surrounding the in-house procedure adopted by higher judiciary to look into complaints of impropriety by judges? Is it really prudent to believe that having co-judges to look into allegations of impropriety is sufficient mechanism? Do you think that the existing setup leads to erosion of public faith in the institution? And what are your views on the justification of such a system, or any suggested changes that you would like to make?
All right. I don't know whether you know that I have been part of the judge's inquiry in 2 cases. Right. When I was judge in the Odisha High Court, I was part of the in-house procedure inquiring into allegations against 5 judges in the Karnataka High Court. Right. Right. Wild allegations were made. Right. And we have made all efforts to find out the truth of it. Right. All nothing. Nothing. Right. And I'll tell you, the 5 allegations against judges of womanizing. Finally. And in a particular hotel in Mysore. Right. Ultimately, the inquiry we found on that day, all the 5 judges were away. Right. And they produced material for us. One was distributing cards for marriage of their some relation. One was lying in the hospital. Right. One was having marriage anniversary with his wife in the hotel. Right. And what you call, one judge was, nothing was come out, nothing came out. Right. There was only one judge who was earlier district judge of police. Right. So we thinking maybe he is involved. But the story was such, right? The story was entirely different, right? And nothing of the sort was there. They were all in different places. And somehow it came out in the newspapers. Then it came out in the Times of India. And Times of India, people called them. I said, you have kicked here, what do you say? No, we have said only high-ups. Then why high court judges have mentioned local papers converted high-ups into local judges, high court judges. Right. Then he found nothing is there. And the entire inquiry was initiated on the basis of a IB report. IB we called her. She was a lady. Where you are, the entire inquiry was initiated on this. What happened? Right. come and produce evidence if you have. She replied, I have no evidence. I have made my report on the basis of rumors. Local rumors in Mysore. She refused to give it. We submit the report to CGI then. Justice Khare looked through the entire matters. My goodness, what has happened? By that time, Karnataka judiciary had been very, very badly damaged. High Court had been very damaged, very badly damaged. People are losing confidence in the High Court. This is the state of our judiciary. This is one case, right? Where we found the judge was innocent. We filed the report, right? And the media was responsible. For which Justice Thakur sitting then, this P.S. Thakur, sitting then in Karnataka High Court, in the judicial side, initiated contempt proceedings in the media. So he was going to haul them up. On what basis you have said all this? We have damaged the High Court. The media rushed to the Supreme Court. And the Supreme Court just stayed the contempt proceedings. Right. And put the contempt proceedings to cold storage. Right. Because the media would have been, the judge knew when he stayed, the media would have been in trouble. Very badly in trouble, because the person who did it had the report, he had seen the report. You see that? Right. But soon thereafter, Indira Jaising filed a petition in the Supreme Court and said, please publish the report. Right. The judge, he didn't know what it was there in the report. This is Radha Babu. He said, no, that report cannot be. It is confidential, cannot be. Today, I must say, if the judge should have directed publication of it, if the judge had directed publication of the report, and it was a case of an innocent case, and everything was discussed very well in that particular report, then the public would have been very happy, wait, take the one, inquire to take one. Right. This is a case where, in other words, I say, in-house procedure is a must. Absolutely a must. But mind you, when the in-house procedure was going on, we gave public notice of hearings. Right. Both in Mysore and Bangalore. We gave, anybody who wants to say anything, please come and say. If you have any evidence. Right, they came and say, but the procedure was announced in the four corners of the room. Right, no public was allowed, no media was allowed. Why? Otherwise, the judge, before he is condemned, how will he function as a judge? You have not found him guilty as yet. How is he function as a judge? Right. And at that time, I remember after reading out that the one judge, he met me in Guwahati after the report had, he met me somewhere after the report was out. I don't remember very well. He walked up to me and said, he met me in Dhasa. He walked to me and said, sir, you know what happened? Whenever I was walking with my wife in the park, so comments used to come from outside. This man must be walking with somebody else. This happens. You don't know how media can damage one's reputation. Right. So therefore, when a judge is functioning as a court, as a judge, to ensure that public has faith in it, let the procedure be held internally, in-house procedure, and ultimately report be published if he is found guilty. If he is found guilty also, in any case the matter goes to the parliament. Right. The Supreme Court cannot do anything. There will be impeachment procedure. Supreme Court cannot remove it. Right. So this is the second case I handled as an in-house procedure member. Right? And we held a judge of the Calcutta High Court as guilty of misdemeanor. Right? And Justice Sen was there. The whole matter was then sent to Parliament, and Parliament impeachment proceedings started. That's what found him guilty. Right? Then it was went to Lok Sabha. At that time, he resigned from service, from the judgeship. Right? So, if he is found guilty, in any case, it cannot be kept by the Supreme Court. But Supreme Court accept it after 3 judges have given the finding in a procedure. It has to go to Parliament. And Parliament whole thing will debate it. Nothing is confidential in Parliament. It will be out in the papers. Right? Mr. Jaitley supported our findings in that Calcutta matter. Right? Then it went to what we call Lok Sabha. The day it was to come up to Lok Sabha, he resigned. Right? So, guilty or no guilty, you know how Justice Dinakar also ultimately resigned. Right? Right? So, the minister, once he got the report. So, therefore, procedure is all right, but in case of the inquiry, in my opinion, inquiry report should be published in case is innocent, so that everybody goes to the materials, right? Public gets satisfied, no problem, because that judicial order there cannot be published. And in case of he is guilty, in any case the matter will be debated in Parliament, right? And so this is what I think should be the approach. Yes.
Thank you, sir, for that answer. Next question has been sent to us by Nadia. It is a slightly different question. It's about arbitration. She asks, arbitration is mostly in the metro cities. How can a lawyer practicing in district courts of non-metro cities move towards and excel arbitration?
See, the lawyer has to choose whether he will do arbitration or will practice the district courts. And that choice will depend upon his circumstances. Right? Where is he staying? Where are his parents? Whether there is a house there in the metro cities, a house rental there. So all aspects have to be seen. He has to choose. What if he is totally bent upon doing arbitration? Then he has to move out from these small towns, right, and go to the metro city where he can do arbitration cases. As far as arbitration cases are concerned, maximum arbitration cases are there in Delhi. And I am now doing arbitration cases. Because I decide to do arbitration cases, I stay back in Delhi. Otherwise, and my son and grandson, my daughter-in-law, they were all here, therefore I stay back. Right? But I could have chosen, no, I don't want to do arbitration cases. After retirement, I will go back to Odisha, stay back. And be comfortable in my own house, in my own place. And maybe I become a state human rights commission chairman someday. Then I don't want money. So that's a matter of my choice. So today, it's like Delhi. If you want future itself, you can do arbitration. It's Bombay, you can do arbitration. Hyderabad, you can do arbitration. Bangalore, you can do arbitration. Plus, Hyderabad and Delhi and all these places, you can do other cases also. But slowly, time is coming when if you want to position yourself for arbitration practice, then you have to concentrate only on arbitration cases and go to the courts only when the awards are challenged or in connection with arbitration. Now, you can't put your hand into everything. Then you lose out in the court. Right? Yes. Next question.
The next question will be asked by Navya. Navya, unmute and ask.
Good evening, sir. Sir, so do you think the public disclosure of assets by judges of the top court be made mandatory in place of voluntary so as to ensure transparency in the collegium system? And if yes, then how can this be implemented?
See, judges have. Parliament has not yet made any code of conduct. They can legislate rules. Right? They can legislate rules and make a code of conduct, but they have not done it. But since 94 or 95 maybe, a code of conduct is in place for judges. And that code of conduct has been adopted by the Supreme Court judges in a full court and by High Court judges in their respective courts. Right? The moment a judge is sworn in as a judge, say in the High Court, he has to file that. Right? His asset statement, assets and liability statement. That goes into record. Right? And that record remains. Supposing tomorrow, some judge is supposed to have acquired a lot of assets during the tenure as a judge. That document will come in place, will help. It's not confidential, it can be asked for. The court can look into it, the judges can look into it in inquiry. Right? So therefore, see, why give it to the legislature? Why not do it self-imposed procedure? So judges, the self-conduct procedure is already in place by virtue of resolutions adopted by the Supreme Court. There are a number of factors. One of them is, after a lot of debate, one of them is whether judges will drink or not. Right? So, in that they have passed a resolution that they can drink all right, in 1979, right? But not in public. Not in public. That's part of his freedom, but not in public. Public means you can't go to a club and start drinking. Right? Right. So long as you are a judge. So therefore, there are values. You don't know. There are statement of values. You can also go through it. You can download it also and read them. It is there already, asset statement. Right? I have given it. I have given it when I was judge in the Guwahati High Court. Right? I have given it when I was judge in Chhattisgarh High Court. I have given it as in the Odisha High Court, everywhere. And I have also given it in the Supreme Court. Right? And in the Supreme Court, they told me, do whatever one TDS told me. Don't give your bank account number. You can say you have got so much of bank deposits. Right? Don't give your bank account number because it may be hacked. So somebody else may take away your money. Don't make them. Right? Yes. So it is there already in place. It's not necessary that law should be made. The purpose is to ensure that whenever a subsequent allegation is made, that asset statement can be made. Right? Yes.
Yes. Yes, sir. So next question has been sent to us by Abin, and he asks, why do you think that the Indian Supreme Court has not been able to select even one distinguished jurist as a judge, despite it being provided for in the Constitution? Is it because of the dearth of jurists in India, or due to some other reason?
No. See, now tell me who's a jurist? Who do you find a jurist today? Bolo. Can you find out? Do you have anybody in who's a jurist today? Are brilliant people, all right. Today, who is a jurist?
So can I answer that question?
Yeah.
Yes.
So a jurist basically means an expert or someone who writes on law, right?
No, I'm not saying that.
Yeah.
I understand the meaning of jurist. You name a jurist.
The one name that I can find on top of my head would be Dr. Ubendra Bakshi.
Yeah, Pedal Bakshi, he could have been considered. Right. But why he did not consider, I don't know. It is possible because of his views. Mr. Follower, you follow? Controversy, a lot of controversy comes. Brilliant man, writes very well. But that time, there will be many claimants. There will be Upendra Bakshi, there was Upendra Bakshi, then there was that gentleman who started National Law University. What is his name?
So Professor Madhava
Madhav
Menon.
Menon.
Madhav Menon. Mohan Gopal. There were many claimants. One Justice P.K. Tripathi was there, Dean of Delhi University. किसको ले? Government may not agree with you. And today is still worse. But let me tell you one thing. And if possible, you must read that lecture. That lecture was delivered by Justice Prakpata in some university. I have read that lecture. The question was, which source of recruitment is the best? Jurist, lawyer, or judges from the lower court, from the High Court? Is the best for the US Federal Supreme Court? To answer that question in his lecture, he said, all right, today everyone says the best judges of the US Federal Supreme Court have been Oliver Holmes and Cardozo. Oliver Holmes and Cardozo. Right? They're the best. So then he says, why are they best? And they came from two different sources. He said they are the best because they had the mind of Oliver Holmes and Cardozo. So this mind can come anywhere, it's very good. Whether you come from a jurist class, whether you come from the bar, or whether you come from the judiciary, doesn't matter. You may come from any source. Ultimately, what grey matter you have in your head? How much of brilliance you have? How much of understanding you have? Right? So, just don't condemn, right? Sometimes I know Upendra Bakshi, very good, extremely good. I don't know why he was not picked up. But there must have been some reason then why he could not picked up, or somebody did not campaign for him, or someone did not lobby for him, or if somebody lobbied for him, right? Somebody opposed him. Follow. So no doubt he's very good. And he was really a good jurist. He would have been a good jurist. Why he was not taken up, we don't know. So Upendra Bakshi was certainly a jurist. But somebody may have other complaint, or somebody said, no, why Upendra Bakshi, let us get so and so. So these are the controversies that take place. Right. All right.
Yes, sir. Next question has been sent by Saurav. He asks, sir, do you think that there is a need for judicial ombudsman for dealing with matters related to judicial impropriety, considering that the in-house procedure is entirely led by sister or brother judges of the accused?
I don't agree with this view. Right. I don't agree with this view. Ombudsman is another human being. Another human being. Right. With all the frailties, We have great Lokpal and Lokyukta. You see, Lokpal, who will ultimately appoint? Appointed by the government, by the president. Now, Ombudsman ultimately is final appointing authority is president. And president under a constitutional action, whose advice? On whose advice? Council of Ministers, that is the constitutional position. So whoever the government wants, they appoint him as ombudsman. And when Justice A.K. Patnaik writes a solid independent judgment which affects the government, they have A.K. Patnaik removed to the ombudsman. Because the ombudsman owes his appointment to the government and he will oblige them. All right, I am doing something. Right. And A.K. Patnaik is finished. His independence is finished. He wrote a what you call a very independent judgment. He is finished. I have not accepted the appointment after it happened. Right. I have kept myself doing private cases and all that. Right. But for judges' appointment, Supreme Court, they should not, in my opinion, be susceptible to any other outside influence. Yes.
Sir, I just wanted to ask, will you be taking more questions or do you want us to, how many more questions will you be taking right now?
You can go up to 6:45.
Okay, sir. So the next question has been sent to us by Nakul. He asks, what are your views on 50% reservation for women in judiciary? So that is the question.
See, we must have adequate representation, right? No doubt about it. But this 50%, we must do as many women, they should be available. Huh? Just appointing judges will not do, right? In Orissa, for example, there are women lawyers. Where the women lawyers, they must be competent also. As far as possible, we should accommodate a woman judge. No doubt about it. Right? And they are good. Not that they are bad, they are good. But they should be able to deliver justice. They should have, once you find somebody is doing good, woman lawyer, must take as a special case. But first satisfaction is, will she be able to perform as a judge? Right? If she is not able to perform, just put her there, then you have a problem. And I know there are having a lot of problems. Where women judges have been appointed, right? They have not come up to the mark. Right? If they come up to the mark, it's very good. No problem. So we can't go this 50% quota, but 50% women should be there, available for appointment. If they are there, please appoint them. No problem. And today it's possible, tomorrow, today it may not possible, after now it will be, because now see, I find in most of the arbitrations, many women lawyers are appearing. In the Supreme Court, many women lawyers are appointed. When we were there in Orissa High Court practicing, there are 2 or 3 women lawyers. Right? And a selection had to be made out of those 2 or 3 women lawyers. If they were good, they could be picked up, otherwise not. So gradually, when the number of lawyers joining the practice, joining the profession increases, or number of lawyers who become district judges increases, they will come up. They will be definitely taken up. But rather than 50% karna hai, and then we have to do it, that we have to be very careful, because ultimately the judges are delivering justice. Right? Yes.
Thank you, sir. So the next question has been sent us by Abhin. He asks that in 2014, you raised concerns about the way judges were appointed and called it give and take policy. So could you please expand on the same?
You see, what happens is, five judges are there in appointing Supreme Court. Right? And as the judgment goes, if two of them oppose the appointment out of five, then the Chief Justice will not recommend that judge. That is the judgment. Second judge's case, what you call the nine-judge bench. Again, that was reviewed by Justice Mariappa. That's what they're just not Mariappa, what's his name? Anyway, that's the view. If two judges are appointed, its initiation is by the Chief Justice. If Chief Justice does not want anybody, he cannot. Right? Nobody can say other than Chief Justice rule. But if Chief Justice wants somebody in the Supreme Court, and out of five, two oppose, he also cannot come. Right? In other words, a minimum of four judges must agree. If the Chief Justice is not able to get those four judges with him, he cannot recommend him. So, actually, what happens thereafter is that groups are formed. Two of them get together and say, we will not support it. You just cannot say it. Then Chief Justice says, all right, what do you want? Then say, we put this candidate of ours. Then we agree with your names. Right. So, if three names have to be recommended, one of them will be there, two judges. Then the consensus goes, it gets appointed. So, this is what I say is a give and take process. Right. Because a consensus, they try to form a consensus. The appointments come. One will be your candidate, and one will be our candidate. And that is what is pushed. Right. This is the problem. And therefore, I had supported the NJC Act recommendations. NJC Act. The Supreme Court, in my opinion, should not have struck it down. Should have only struck out those two eminent persons who are member of the NJC. Right. Struck them out and leave the rest. That would have made three judges, one law minister. It's all right. We're binding on the Prime Minister. We're binding on the President. That is my view. I have written an article criticizing that judgment of the Supreme Court. Right. And it has been published in the Journal of the National Law University of Delhi. Yes.
Yes, sir. Next question has been sent by Neil, and he asks about virtual hearings. He says that with the COVID numbers falling, courts have started going back to physical hearings in a phased manner. Do you think virtual hearings should still be kept as an option even after the pandemic ends?
No, after the pandemic, why should it be? It should not be there. So long as the pandemic continues, right? We must have hybrid, we can have whoever wants and all that. But after the pandemic ends, why should there be virtual? Though I would also like virtual hearings in arbitration, right? And arbitration we hold because when it comes to international arbitration, one is sitting in Singapore, another sitting in England, third is sitting here. Then how do you hear it? Travel expenses will be there. But we have been going to Paris for arbitration. I have been going to Singapore for arbitration. And they have been also coming to India for arbitration. Right. But after the virtual hearing come, we have become more comfortable. Right. But our travels have gone on. Travels are also enjoyable. Right. Life is virtual, it's all right, at home it's all right, but after some time, society must be there, thriving. This is no hearing. Life must also be there. I was traveling to Hyderabad. I was traveling to what do you call Raipur. I was traveling to Bangalore, traveling to Bombay, and I used to take my wife along with. She is no longer there. She expired in the COVID. Right, my wife expired in the COVID, and in May 2021, 18th May, I lost her. But I'm happy that I took her around the world, and also I took her to all the places, and she stayed with me in the hotels, and she lived a very comfortable life. Right? We don't know when life will come to an end. Why not see the world? Why not see the world? Why not travel? Why not meet people? Right? If you stay at home, you'll become old. Yes.
Yes, sir. So next question has been sent by Ujwala. She asks that while the notion of constitutional morality can be an effective instrument in enforcing socio-economic rights, does there also lie the risk of judicial despotism in its liberal use that may ultimately lead to a dilution of separation of powers in the near future?
First, you see, the problem with this judgment, there's a lot of problems. What is constitutional morality? Subjective? Morality is always subjective. Morality is never objective. It must appeal to your conscience. Morality must appeal to your conscience. This concept of constitutional morality, I don't understand it. It has evolved in one judgment in the Supreme Court. And even Mr. Upendra Bakshi also praised this. But what is constitutional morality? I can understand there are constitutional values. Equality is one of the constitutional values. Freedom of speech and freedoms, another constitutional value. Personal liberty, a third constitutional. They are all found in different provisions of the Constitution. But what is this vague concept of constitutional morality? It's language. In my opinion, it's language, very opaque language. We are not able to clearly understand what this is. And the Attorney General, Mr. Venugopal, has been saying, what is this constitutional morality? The arguing case of what is the constitutional morality? When you write, start writing judgments like this, right? Using expressions, wonderful expressions. Ultimately, when you try to apply this, no scope for application. You point out Article 14, Article 19, Article 21, Article 22. Right? You point out and strike it down. Or say this has to be done. But constitutional morality, in my opinion, is a vague concept. Right? I don't agree with that view, but it's part of a judgment. What can you do? Yes.
Okay, sir. So next question has been sent to us by Eliza, and she asks that Justice William Douglas wrote that the right to dissent is the only thing that makes life tolerable for the judge of an appellate court. How far do you agree with the statement? And are judicial systems obligated to treat dissenting judgments with any special treatment above and beyond merely indicating them as being separate from the majority judgment?
See, basically, a dissent is separate from the majority. Nothing else but that. But it has a useful purpose. What is the useful purpose? Let us say somebody writes a dissenting judgment in the High Court. And majority view is something. 3 judges, 1 judge dissents, 2 judges take the majority. That judgment will go to Supreme Court. And the Supreme Court, while deciding an appeal, say that no. I think dissenting judgment is better result. The judge may say in the Supreme Court. So they may reverse the majority view and say Dissenting judgment is the correct view. Right? And I'll give you another concrete example. What is the meaning of dissenting? It may be in review also, Supreme Court may review what said dissenting view is correct. Right? Ultimately, the man who writes the judgment, man's perception. Right? ADM Jabalpur. Have you heard of ADM Jabalpur? What is it? Habeas corpus. The habeas corpus judgment was written by two judges. They said during emergency, the right to life and right to personal liberty cannot be suspended. Though there is a provision in the Constitution, the emergency, any fundamental right can be suspended. But ADM Jabalpur said, written by Justice A.P. Sen and Justice Vekanka, A.P. Sen had authored it. He said, it is not conferred by the Constitution, it's not a right conferred by the Constitution, it's not part of fundamental rights only. Fundamental rights only recognize the right to life. Fundamental right to recognize the right to personal liberty. Right? It said, right to life is inherent as a natural right in every human being. Liberty, personal liberty is inherent in every human being. Constitution only recognizes it. Nobody can suspend, therefore, the right to life and right to liberty. They are inherent to that human being. Right? And therefore, these are not suspended. That came to Supreme Court. 5-judge bench, Constitutional bench heard it. 4 judges said, no, they also remain suspended. They are conferred by the Constitution. 1 judge, Justice Khanna, bold judge, he felt how important it is to save the life and liberty of citizens. But sorry. I agree with Madhya Pradesh High Court. It is inherent in every human being. No parliament and no government can suspend it. Constitution will recognize those rights. Dissenting view. Right. Majority was different. Judgment was delivered. After emergency, Justice Khanna's view holds good. Those 4 judges gone. Though, right, gone. You follow? So this is the value of dissenting judgments. A dissent today may become a majority tomorrow. They have a lot of values. They should be recorded. And they should be kept in the records. Right? But the idea, as far as possible, the judges should sit down and decide whether we should all agree or there should be a dissent. Right? If that course of has been followed and still one judge said, no, I want to disagree and give a dissent, that should be permitted. Because in future we'll never know which view would have been correct. Today, I have views with regard to many big judgments of the court, which in my opinion are creating problems for the country. Very bad problems for the country. Right? And I hope Supreme Court have wise people and reverse those judgments. Otherwise, very dangerous. Right? And those circumstances that said that is all right. But circumstances change. A constitution is not meant for 10 years, 20 years. It's meant for hundreds of years. Right? How long it will live, we don't know. That constitution will remain. So it should be very dynamic. Very dynamic. and a view which has been correct for 30 years, suddenly the Supreme Court must think that this view is very dangerous for the country. Change it. You see, a lot of thinking is going on with regard to sedition law. Sedition law, when that provision, section 124A, in the Indian Penal Code should be struck down as unconstitutional in a democratic country like India. It was a provision in Indian Penal Code made in the colonial days, where this colonial law should survive the constitutional law. You have to think, right? Yes.
Yes, sir. So a concluding question from Shrishti and Navya. Shrishti asks that if there is one aspect of Indian judiciary which you would like to completely overhaul, which would that be? And Navya asks that like you to share some of the insights about your life as a Supreme Court judge with the students.
No, I think I have not thought of many aspects, right, of which provision, but I think the Supreme Court judges' appointments must change. And I think the NJC Act was in the right direction. It was a constitution and it was passed unanimously. Right. I think the Supreme Court should not have struck it. Right. They should have only said two eminent persons were included here in the selection process, apart from three judges and one minister. Right. Two eminent persons should not be there. Because two eminent persons' difficulty is there are three judges in NJC, National Judicial Commission. Law minister is there. Three judges represent the judiciary, highest of the judiciary. Right, Justice of India and two judges. Law minister again represents democracy, represents the government, representation. Two eminent persons not properly defined. Right. Those two persons could be with left leanings. These two persons may be with right leanings. Right. And if they are added with the law minister approval of the government, there is a deadlock. Right. And we don't want judges. Frankly, I would not like judges with an ideological background, completely one-sided. Because if you look at the Constitution, it does not have an ideological bias. It only says you do justice, do equitable justice, provide all those things that are there in the anti-principle. It conceives of a welfare state, livelihood, socially equitable order, right? Then minimum wages, right? Equal pay for equal wages, that proper living conditions for agriculturists, right? You look at the provision, very nice provision. Education to minimum education to all. These are the provisions, but does not say whether it will be done through a left ideology or through the right ideology, a capitalist system or a communist system. Nothing. Right. But political parties have their own ideologies, programs. Right. Law minister, one law minister representing there is all right. But two more eminent persons, if they are brought in, right, and they are of one ideology and the appointment of two eminent persons different, then finished. They strike down two eminent persons. And let the there is a judgment of the Supreme Court, 5 horsemen, that if the Constitution, those provisions of the law which are constitutional can be severed from those provisions of the law which are not constitutional. Doctrine of severity can apply it, uphold those provisions which are constitutional, strike down those provisions which are not constitutional. Left it. So it would have been NJC with 3 judges and 4 lawyers, then they would have taken a fresh call whom to appoint. But that provision, that law requires whatever that collegium, that agency recommends is binding on the government and the private. Once only will send it back. Second time is a repeat, it's binding. That would have been a great thing for the Supreme Court. I feel the Supreme Court has lost a historical opportunity. And they got to change the appointment system, but they didn't do it. That's the greatest thing. And then what you want to say? Well, judges.
Yes, sir, like your life as a Supreme Court judge and some insights for students.
I have been the chairman of National Law University, Law University in Raipur, by virtue of holding the post of Chief Justice there. I have been also the Chancellor of National University in Bhopal, by virtue of holding the post of Chief Justice of High Court of Madhya Pradesh. When I came to Supreme Court, I have been the visitor of National University, what they call Orissa and Bhubaneswar. I have also been the visitor in the National University, Bhopal. Right? Representing of India. So I am very keen on legal education. Right? Very keen on legal education. And I have been, perhaps because of this interest, I have been entrusted recently to select the director or the vice chancellor of National University of Orissa by the Chief Justice and the Executive Council, Supreme Court. And I selected Professor Ved Kumari. I was also interested in selection of the National University, Dharamsala National University in Bhopal, in Jaipur. And I selected just there, and this is Mr. Nagaraj, Professor Nagaraj from Bangalore, right, National University. So I've been involved, right, and I was very much involved in National University itself, in the construction of Tamil. Right, because I feel it's a very important area. During our time, we did not have all this. I am a product of Mansur Law College, with asbestos roof, right? We didn't have all this infrastructure. We used to go in cycle. Classes used to start at 7 o'clock, over at 9 o'clock. Right? Hardly any teaching. There were part-time teaching. And when we used to take the exams, I found everybody's copying. Right? So things have changed. Now National University is producing very good students. But the only thing is, because of compulsions, the expenditure that takes place, they are taking jobs. They are not coming to practice. Right? And some of them are going to judiciary now. It's good. Some are judiciary. Right? But it's your choice ultimately. It's your choice ultimately what to take up or what not to take up. Whether you like it or not, that's a very important thing. I was a member of the governing body, National University, in Bhopal, in Bangalore, when I was still in Madhya Pradesh. Each time the governing body meeting held, Jesus used to be in the chair. Very important lawyers to go, why are these products not with the bar? Right? Why are not they going out to the bar? Why are they not coming to call? Why are they taking the corporate jobs? Right? And this is the situation. The same question was in Madhya Pradesh, a question was put, and they said, so the student answered that we are not going there because the we don't feel comfortable with this audit actually. We don't feel comfortable with the bar. Right. I said, why? I asked them why. I was then the chairman of the chief justice. Why? They are of below standard. Right. Most of the lawyers are below standard. Right. Now, I was chief justice, I already had an experience. I told them, your first year of product, a gold medalist who stood first, appeared before me in one pattern. I put one question, he could not answer. He is your best product. So I told them, don't think just by studying law, you are brilliant. Oh, you don't become brilliant just by studying. You get the fundamentals. But to become a good and capable and brilliant lawyer or judge, you have to go through the grinding of 10 years in the bar. Right? Then you will understand what it is. Unless you see the nuances of the practice, you will not. If law is not theory, law has to be a lot of real practice. So my instruction to students is that books will not help you only. You have to see the practice of the field to understand what the law is. Follow. I'll give an example. You know, Section 25 of the Evidence Act, in confession to a police officer, is not admissible. Everyone knows that. When I was a student, I used to think, why it should not be admissible? Why? If somebody has confessed, why will not be admissible? But it took me 5-6 years of practice to understand why confession to a police officer. How dangerous it is. Right? A police officer will give one lathi and said, you admit to the sentence. Finished. You are convicted. Right? So you will understand the implications and meaning of law only if you. Somebody has, I think it's Oliver Holmes was saying, life of law is not logic, not reasoning. Life of law is experience. So you not understand a principle of law unless you have some experience in the field of that provision. Follow? This is what I want to tell you. You have to continuously what the choice is yours, which field you want to go. So that is why even those who go into corporate practice, they have to come to a judge or to a lawyer for some opinion. Finally, they'll get money all right, fixed salary. And that is why again, jurists may not always be suitable. He is an academician, become jurist. He may not always be suitable, unless he has that kind of depth and understanding. But he can be at times. You never know. Right? You have to have a lot of experience and to be able to deliver judgment. Judge is known for his wisdom, not for his brilliance. Wisdom and impartiality. integrity. These are qualities which cannot be acquired as a student. Right? It will be acquired by years of experience. Right? Thank you.
Thank you so much, sir. That was very insightful. So now I would like to request everyone to turn on the camera for a virtual picture. Smile. Thank you, sir. Now I would like to call upon Abhin to give a vote of thanks.
Thank you, Toshita. Very good evening, sir. On behalf of the informal discussion group, NUJS, I, Abhin, would like to express my sincere gratitude to you. We are all extremely honored that you graced us with your presence today. It was truly a privilege for us to have interacted with you. I would like to thank you for enlightening everybody present here on various legal, constitutional, and judicial matters, and also for sharing your experience. I am sure every one of us is taking away something valuable from today's session, extremely insightful session. Now, I would also like to thank the members of the IDG committee who contributed to the successful conduction of this session. Next, I would also like to thank the members of faculty and other attendees for their graceful presence and for bringing up such valuable, wonderful, and relevant questions. Thank you so much.